Thank you, Mr. Chairman. Mr. Secretary,
Morning,
thanks for being here. I'd like to talk to you today about the Office of Labor Management Standards work that they're doing on a proposed Persuader rule under the Labor Management Reporting Disclosure Act. Just so you know, I'm a labor lawyer from South Alabama. We don't have very many big employers. Most of our businesses that employ people in South Alabama don't have HR departments. They may have somebody that's in charge of HR that's got half a dozen other things they're responsible for. So when they're in a situation where there's a union organizing campaign going on, they don't really have anybody in-house that they can go to help them. They've got to go get somebody like me, and there are a number of very fine lawyers down in our neck of the woods that do that. Now, the problem is that up until now, it's been a pretty good bright line test. If the lawyers that were given that advice weren't actually communicating with employees, we weren't covered by any sort of a Persuader rule. Without a bright line test, that's going to put these lawyers in a very difficult position. But more importantly, it puts those employers in a difficult position because they don't know what the law is. And there's no way a small to medium-sized business can know this area of the law because it's so fairly granulated, as you know very well. The American Bar Association has registered its very strong concerns about attorney-client privilege issues here. And as a lawyer yourself, you know how important that is. Now, here's the truth. The unions, when they go on these organizing campaigns, I'm not saying they don't tell the truth. They're selective about which truths they tell. And the only way for an employee to get the entire picture is if the employer talks to them. And under the labor laws, the employer has a right to talk to their employees. But there are rules about what the employer can say and do and rules about what the employer can't say and can't do. Now, if the employer can't turn to a lawyer that's a professional in this area and say, tell me what I can say and do, and also tell me what I can't say and do, without the fear on the lawyer's part that the lawyer is going to be brought under this rule, then effectively we've denied legal counsel to the employers, and just as importantly, we've denied crucial information to the employees before they make that very important decision when they go to vote on whether or not they want a union. So I want to register that concern to you, and in the 30 seconds that are left, please give me some information that would tell me that you're not going to put us in a situation where lawyers are effectively prohibited from giving that sort of advice.
There's nothing in the proposed rule that is currently under consideration, by the way. There's nothing in the proposed rule that prohibits the employer from saying anything to their client. The LMRDA requires that consultants report their agreements that are designed to persuade employees directly or indirectly. That's not my words. That's what Congress passed in 1959 about whether or not to choose to join a union. And in 1959, when Congress debated this, the attorney-client privilege was brought up as a reason not to have the word indirectly in there or something of that nature, and Congress explicitly rejected that. So this is about transparency. This isn't about affecting attorney-client relations.
Mr. Secretary, I'm out of time, but I'd like to have a discussion with you away from here because I think you and I have a different view of that. I yield back.
Gentleman yields back. Thanks for trying to navigate the